would your lordships be kind enough to turn to page 4616 in the bundle of authorities. That's behind tab 67.
Page again, please.
4616. This is a judgment of the United States Court of Appeals, second.
We sometimes have to get our papers back up onto the screen when we return after lunch. 461, Attorney General of Canada.
That's the one.
Thank you. I'm very sorry.
My Lords, this is a decision of the United States Court of Appeals, Second Circuit. The case concerned a claim that was brought by the Attorney General of Canada against a tobacco company for participation in smuggling. One sees at page 4639 that the court recognises the need to consider the revenue rule in this context. Please could I invite the court to read pages 4639 to 4640 under the heading Direct and Indirect Enforcement. One can safely skip both the footnotes and the citation from Peter Buchanan, which the court has already considered.
Where do we start?
At the bottom of that page, please, my Lord. And then turning over the page at 4641, third paragraph down, we see that Canada had sought to distinguish what it was doing from something that would be caught by the revenue rule, in particular in relation to seeking damages for the costs of enforcement against the smugglers. So it was seeking in part to recover the costs, for example, of paying police forces and no doubt customs officers to try and enforce the tax laws which were being evaded by the smuggling exercise. The court said, we do not believe that the mechanism for the enforcement of a tax law can be so easily separated from the tax law itself. It would certainly be anomalous for the court to permit the collection of the law enforcement costs while holding that the object of those law enforcement efforts was uncollectible, particularly in the light of the separation of powers and foreign relation concerns discussed above. We must decline to allow Canada indirectly to enforce its revenue laws simply by pleading tort damages based on the cost of enforcing those laws. And then we see that they also took the view in the next paragraph that the claim would essentially involve pleading acts that were iure imperii, i.e. of a sovereign character, and that too would fall within the scope of the principle of law recognised by Lord Denning in the Ortiz case, which I'll come on to when dealing with ground 2. That decision was the subject of a series of cases to like effect. There was then...
Can I just ask what submissions you make on that authority and how it has bearing on this case?
Yes, that is another common law jurisdiction recognising that the revenue rule precludes indirect enforcement, which encompasses in this case a claim for damages for compensation for revenue lost, which is not based, see page 4639, on a final fully adjudicated Canadian tax judgment. That's the first point. It can encompass something that doesn't require an underlying tax judgment being enforced. And secondly, it extends so far as to cover related claims for damages, for example, in costs of enforcing tax provisions, which on any view are not going to involve in themselves an unsatisfied tax liability. And so this is authority from a Commonwealth jurisdiction, former Commonwealth jurisdiction, a common law jurisdiction, dealing with the revenue rule, applying the same principles and finding that it wasn't restricted to simply claims for enforcement of a given tax liability. Now, there was then a detour on this line of cases to the Supreme Court in a case called Pasquantino, but nonetheless the US Court of Appeals reaffirmed the decision, and my lords will find that in the decision of the European Commission and Nabisco, which is at page 4676. That's behind tab 71. The editor's note at 4676 describes the procedural interstitial stages of an appeal to the Supreme Court in Pasquantino, a referral back, essentially this court in the European Commission case, the European Community case, requiring a reconsideration of the case law in the light of Pasquantino. In this particular case, it was the European Community that was suing for effectively lost revenue and other damages facilitated by smuggling of contraband cigarettes. Circuit Judge Sotomayor, as he was at the time... Sorry?
She.
Oh, I'm sorry.
Yes.
Beg your pardon. Circuit Judge Sotomayor found that the case law was to be upheld on exactly the same principles. She said in terms halfway down the page, at page 4677, we have considered Pasquantino and the parties' letter briefs concerning its impact on their first decision and reinstate.
Where on the page is it?
That's letter E. Letter E. So, notwithstanding the findings of the Supreme Court in Pasquantino, the same principles were applied. And again, rather than Canada being the claimant in this case, it was the European Community. Just on the observation of Lord Mackay, Williams and Humbert, you have, I think, my submission that in any event that does not constrain the case law to requiring an identified tax debt in the sense of imposition of a tax. It is capable of encompassing an unsatisfied revenue liability, which in this case would be a claim for a refund of income tax that's been wrongly paid out. It was capable of coming within that expression. I think the final case I need to go to on the revenue rule and its rationale is the QRS and Franston case. This is in Authorities Bundle, page 3784. If we look at the head note at page 3784, the case concerned essentially a Danish company that had allegedly stripped its assets to avoid a tax debt in Denmark. It was then pursued by the Danish tax authorities, and the relevant claim was brought against one of the directors who was a defendant in England. So the claim was brought in England by the liquidators of a company to enforce what was ostensibly an allegation of asset stripping by principally at the behest of the Danish revenue. The facts in the claim, as pleaded, is set out at page 3785. And we see that it was framed as a claim for damages and or reimbursement and or compensation for breach of statutory duty under Danish company law, alternatively breach of fiduciary duty, and so on. Lord Justice Simon Brown, at page 3786, states at letter G, "It is a fundamental principle of English law that our courts will not enforce, directly or indirectly, the penal, revenue, or other public laws of another country. On the English authorities, it's clear that the present action falls foul of that rule. In substance, it involves the indirect enforcement of Denmark's revenue law." The issue then was raised as to whether or not the application of the revenue rule would be precluded by the Brussels Convention. One sees the facts then set out at page 3787, and they're broadly along the lines I've simply described. And at the bottom of page 3787, Lord Justice Simon Brown said, "The facts are in all material respects indistinguishable from those in Buchanan and McVeigh, the leading authority on this aspect of indirect enforcement, an Irish decision approved by the House of Lords in Government of India." At subparagraph E, letter E, at page 3788, it states there can be no distinction between the defendant's sale of the company's assets and his pocketing of the proceeds in the Buchanan case, and the defendant's sale of the company's assets and use of the proceeds to fund their purchases of his own shares in the present case. It can therefore equally be said of the plaintiff's claim here, as was said of the liquidator's claim in Buchanan, that the whole object of the suit is to collect tax for the foreign revenue. This will be the sole result of any decision in favour of the plaintiff. So on the facts, the court was endorsing the approach in Buchanan and McVeigh and saying it was indistinguishable. What His Lordship went on to consider at page 3789 to page 3790 was the interaction between the revenue rule and the Brussels Convention. And please could we pick it up at subletter F on page 3789. And please could I invite the court to read at subletter F on that page through to the bottom of page 3790.
Will we finish bottom of 3790?
Yes, please. Page 3792, letter C, His Lordship found that both direct and indirect enforcement of revenue rules would come within the concept of a revenue matter for the purposes of the Convention. So he was is there on all fours with the decision of the Chancellor below in this case. And then at 3794, His Lordship dealt with the rationale for the rule. And please could I invite the court to read page 3794, letter G, through to page 3795, letter D. So that's 3794G through to 3795D. One sees also at page 3796 that this was a case where the unsuccessful appellants sought leave to appeal to the House of Lords, but that petition was dismissed. In the light of that case law, we've identified 4 rationales for the revenue rule, of which one has gained what we accept as the greatest acceptance. That first and predominant rationale is that based on extraterritoriality and the limits, permissible limits, on the extraterritorial exercise of a sovereign power. In short, foreign revenue authority should not be using the court apparatus of another state to recover its state funds wrongly paid away as a refund of withholding tax. Secondly, issues of comity and the avoidance of embarrassment have been raised, particularly in the US jurisprudence. Thirdly, case law has referred to the fact that alternative arrangements have properly been agreed between friendly foreign states, sovereign states, on a mutual basis, and the executive has been recognised as being best placed to assess the extent to which the revenue rules should be abrogated on a bilateral or multilateral basis.
Have we seen that proposition in many of the cases?
I think it's been referred to in part, in passing, in the QRS decision that we just looked at. It is raised more directly in the Ben Nevis case that I'm coming on to shortly. And the fourth proposition is that it's appropriate for claims in tax to be brought within the courts of the taxing state. It's a quasi-jurisdictional rationale. Those courts are best placed to determine the detail of the tax laws to give it effect. The next part of my submissions, which I will have to take relatively briefly, I'm afraid, is the powers available to SCAT on an international or EU-based basis. We say SCAT had a number of international or EU-based mutual assistance provisions that it could call upon to enforce a tax claim once it had established that tax claim in its own jurisdiction. One example is the US-Denmark Double Taxation Convention. My lords will find that at page 5124, behind tab 100.
What's the legal relevance of these alternative means
has.
What these show, my lord, is that it was open to SCAT, consistently with the revenue rule, to establish its claim in its domestic court and then rely upon the mutual assistance provisions to be able to enforce that claim in another jurisdiction so that they could get their hands on any money that was said to be capable of being achieved for satisfaction of the underlying debt.
Right, but it doesn't preclude them from bringing this claim, assuming the revenue rule doesn't.
If the revenue rule does not apply, then of course they don't need to rely upon the double taxation convention's provisions on mutual assistance. But the Court of Appeal, Lord Lloyd Jones's decision in Ben Nevis, recognised that part of the underlying force of the rational rule was revenue rule was that it was forcing states to agree better procedures for mutual assistance and mutual recognition and mutual enforcement than would otherwise be obtained by chipping away at the revenue rule itself. I can take this very briefly. At page 5135, there is a provision within the DTC that deals with administrative assistance. And in particular, sorry, I've given myself the wrong reference, I think. It's 5154 is Article 27 dealing with administrative assistance. And Article 27.9 over the page on 5155, which I think is what the reference should be. Paragraph 9 says, each of the contracting states shall endeavour to collect on behalf of the other contracting state such amounts as may be necessary to ensure that relief granted by the Convention from taxation imposed by that other state does not inure to the benefit of persons not entitled thereto. So that provides a mechanism by which if Denmark is saying, well, we've paid out sums that are said to be due under the Double Taxation Convention but are not in fact due, if a benefit has inured which shouldn't have been inured to the benefit of that person, then they can invoke the mutual assistance provisions for help. Now, the Ben Nevis case is at page 4194 in the first instance decision. This was a case where HMRC was called upon by the South African revenue authorities to try and give effect to a tax debt alleged by the South African revenue authorities to exist. That's behind tab 54.
Sorry, can you give me the page again?
Yes, it's 4194, my lord.
41.
That's where it starts.
Thank you.
And then within, I'm going to cut straight to the chase because time marches on. But if we could look, please, at paragraph 16, page 4201. And please could I invite the court to read paragraphs 16 and 17. And then at page 4219, paragraph 53, the learned judge cites the revenue rule principle and tracks through much of the case law that's been referred to elsewhere in the other cases, albeit ones we haven't expressly looked at, which nonetheless I'm sure the court...
Sorry, which paragraph?
53,
Yeah.
page 4219, top of page 4220, the learned judge says the policy consideration underpins the revenue rule as identified, and then he says, in my judgment, it is precisely this consideration which led to the formulation of mutual assistance provisions in the terms that have been adopted in Article 25A. Mutual assistance is provided within each convention state by the relevant organs of the collecting state. Had the convention states intended to proceed as the claimants submit, there would have been no point whatsoever in drafting the article the way it was. And he then goes on to consider the question of construction of the relevant provision giving effect to the double taxation arrangements in place. But it's an express recognition that these mutual assistance conventions and provisions have grown up precisely to deal with the revenue rule on an appropriate bilateral or multilateral basis. And for my Lord's note, page 3022 confirms the confirmation of the Court of Appeal in that case, per my Lord Jones, that Lloyd Jones, sorry, that is indeed the basis upon which the mutual assistance provisions have sprung up.
Which page?
Yes.
3022. 3022. Paragraph 6. Paragraph 6 itself is at 3024. Now, a further example of the mutual assistance provisions available to Denmark in this case is the Mutual Assistance and Recognition Directive. I don't propose to go through this in any level of detail, but I would just like to highlight some policy points that arise from it. Please would the court turn to page 5361. This is a directive that deals with mutual assistance for the recovery of claims relating to tax duties and other measures. Recital 5, at the bottom of the page there, confirms that the directive is intended to cover all claims relating to tax duties, levies and refunds, whatever their form, including pecuniary claims.
Sorry, where are you reading?
At the bottom of page 5361 on the right-hand column, recital 5.
For clearer rules would promote.
Yes, they would also ensure that all legal persons, etc., and then over the top of the page, they would furthermore make it possible to take account of all forms that claims of the public authorities relating to taxes, duties, levies, refunds, and interventions may take, including all pecuniary claims against the taxpayer concerned or against a third party which substitute the original claim. We then see in recitals 7 and 8 that this particular directive is seeking to harmonise the formalities that will be used when seeking to entertain cross-border enforcement of tax claims. And recital 12 then says, if at any stage during that enforcement process there is a contested debt, then the whole process gets funneled back into the member state of origin, namely the member state of taxation, so that the matter can be dealt with properly before the courts and tribunals of that state. So this is a mechanism by which member states will lend their assistance to each other to enforce tax debts or tax-related claims. To the extent that it becomes disputed, there's an inbuilt mechanism whereby it's shunted back to the court best suited to determine those tax claims, namely the court of the jurisdiction in which the tax debt arises. Now, as a separate aspect of mutual assistance, there is a separate directive at page 5373, behind tab 107. That's Directive 2011-16 EU, and this permits, save for certain accepted taxes, for example, at page 5381, the disclosure of information and documents between tax authorities. And as we'll see later, it's this particular mutual assistance directive that's been relied upon by SCAT in the course of preparing for its multi-jurisdictional litigation arising from the alleged WHT fraud. My Lords, may I please move on to ground one and develop submissions that have been set out principally in our written case. So ground one is addressed in our written case at paragraphs 53 to 81. And it's addressed in Lord Panic's case at paragraphs 100 to 124. Now, I accept that SCAT's core proposition is that tax refunds should never have been made, and that therefore, looking at their pleading, this is therefore not a tax case or a revenue claim. It says, because there were never any valid claims for refund, payments of the refund that were made pursuant to them should be treated as being of no effect. That seems to be the submission. And that leads to the proposition on SCAT's case that this is not a tax claim and no tax liability is asserted. We say, however, with respect, that this case necessarily turns upon the eligibility criteria for the refunds that were in fact paid out by SCAT. SCAT says, well, this was a common or garden fraud. We say, no, the impact of your pleading and your acceptance of payments having been made under the legislative tax scheme in Denmark is that this is an allegation of an extractive tax fraud. And that is because refunds were made for repayment of income tax withheld at source. They were accepted and payments were made. And what is now sought to be done is to challenge the initial eligibility criteria and whether or not those initial eligibility criteria were indeed met. And it's only, we say, as a result of a pleading of a complicated fraudulent scheme, that SCAT's pleading that there were never any shares owned by WHT applicants and there were never any dividends paid to them gains its colour. So it's only, in a sense, the allegation of an orchestrated fraud operating on a self-cancelling or circulating transactional basis. It's only because SCAT is pleading that they say, in fact, it turns out no dividends were ever paid to you and therefore no tax liability ever accrued. That pleaded case is necessarily reliant upon the prior stage of cancellation or annulment of the payment of refunds of tax that were in fact made.
Pleaded case is based on what?
They necessarily have to knock out the public law decisions that were taken to refund the income tax pursuant to the refund applications. And the way they do that is by a pleading of fraud. My aim this afternoon is to seek to persuade this court that the Chancellor was, with the greatest respect, wrong to equate that as a common or garden fraud. It should have been equated with a tax fraud. And parallels that one sees in other tax fraud cases are pertinent because those tax fraud cases also involve essentially establishing the proposition that the tax was never due and should never have been paid. And the reason why it was never due and should never have been paid was because of an operative extractive fraud.
You're going to have to help me, I'm afraid, about these labels.
Yes.
A tax fraud. I don't know what's built into there.
It is a fraud operated by persons seeking to obtain a benefit as a result of the workings of a tax regime, which leads de facto to a court, when it's considering a claim based in fraud, considering the operation of that tax regime and what benefit is gained from it. So this court must necessarily, the commercial court in due course, at the main trial, will necessarily have to consider to what extent the eligibility criteria when initially assessed were wrong, and whether the SCAT is right to say, after the event, all of this was undone by a fraudulent conspiracy, and therefore we made a mistake. The tax criteria were not met for the refund, and therefore the refund should be repaid.
A well-informed layman would normally associate a tax fraud as something that is done by someone who should be a taxpayer and is choosing to evade his taxes by fraudulent means. What you're doing is extending the concept, and you may be right, but you're extending the concept to a fraud which engages mechanisms of taxation, in effect.
Well, my Lord, there are 2 points, if I may unpack them. The first is does a pleaded case of fraud make a material difference in that the allegation of fraud by itself takes the claim outside the realm of a tax or revenue law? And I will seek to say why that's wrong. And the second issue is a claim for repayment of wrongly paid tax different from a claim to be paid tax that has been imposed but not yet paid?
Sorry, is a claim for...
repayment of a wrongly paid tax different in principle from a claim to be paid tax that has been imposed but not yet paid. So the example I think my Lord Hodge was putting to me was the classic fraud case will be somebody who, for example, is an income taxpayer in this country and suppresses the amount of income that he or she...
Sorry, is a claim for the repayment of a wrongly paid tax and then it carried on?
I beg your pardon. Is that different in principle?
Different, yes.
In principle from a claim to be paid tax that has been imposed but not yet paid?
But are we dealing with a claim for a repayment of a wrongly paid tax? No, we're not. We're dealing with a claim for the repayment of a wrongly paid refund.
Well, my Lord, we say on the facts of this case, SCAT's decision was to recognise that a refund of income tax was due. What has then happened is that those decisions have been annulled or cancelled, and SCAT is then saying, we therefore want the sums that we've paid out by way of income tax back, because they've given effectively a repayment of sums that are said not to be due by way of income tax, and they're seeking to claim it back. So
they say there was no payment of tax at all, therefore there was nothing to repay.
But they say, my Lord, there was no payment of tax at all, therefore the eligibility criteria were not met first time round. Therefore we got it wrong. Now, as it happens, their decision to accept that the eligibility criteria were met brings all of these claims within the scope of the tax net of Denmark.
It's a public law decision, I see that, but at the moment I don't see how it brings it within the revenue rule.
Well, my Lord, it brings it within the revenue rule because the operation of the tax legislation in Denmark is critical to both the grant of the refund in the first place and then the withdrawal of the refund in the decisions that we've looked at. Because this is all a case about whether or not tax is due. Now, tax can either be due, for example, because a taxing authority says to you as a taxpayer, you've understated your income, you owe us some money, or it can arise because a taxpayer chooses to inflate artificially his or her expenses, and the revenues say, well, you weren't entitled to deduct those expenses, therefore you shouldn't have been deducting those expenses. That's sort of two sides of the
both
same.
Cases that lead to a claim for tax. You haven't paid as much tax as you should have done.
Yes.
But that's not this case.
Well, my Lord,
This is not about whether tax is due. The tax has been paid. Tax was certainly due. The question is whether your clients could reclaim it, or claim it rather.
but the SCAT has recognised that these applicants had a claim for a refund of tax by virtue of the
Yes, I understand that. But that's not whether tax is due, is it? Tax has been paid. Tax was paid by the Danish companies.
The tax was paid by the Danish companies, and the question then is who has the entitlement to a refund of income tax on the basis of that payment.
Yes.
So the first stage in withholding tax is always going to be the company has physically paid the
Well,
tax.
that's why, yes.
SCAT. But then you have a series of claims saying we're entitled to have that withholding tax paid back to us by virtue of...
Paid to us. It's never come from you.
Well, my Lord, that is a specific feature of the withholding tax regime, but it's not a difference in principle.
Okay.
The problem with this is whether it's right to treat what SCAT paid back to the defendants as a payment of tax. For all we know, there were shareholders in all these companies, which we understand did pay dividends, many of whom may well have actually made reclaims successfully, so that the tax that was actually withheld by the companies and paid to SCAT may have been paid back to the proper shareholders. We just don't know. To say that what was paid to the defendants in this case as a result of their if you like, fraudulent impersonation of themselves as shareholders was tax, seems to me to beg a rather large question.
My Lord's absolutely right with respect that ultimately what this case is about is a large number of people claiming an entitlement to a refund at the same time.
Yeah.
And not all of them can be right.
But assume the right people got the refund, how can you still categorise what was paid to these wrong people as a refund of tax?
Well, because my Lord, one's not in a position yet to determine who, or if anyone, has received the right
But
payment.
you have to proceed on the basis of Scott's claim, which is these were the wrong people.
Well, we have to proceed, my Lord, on the basis of Scott's claim through the prism of what is the claim that is being recognised when they make the refunds in the first place. And the claim that's being recognised when the refunds are made in the first place is an entitlement to be repaid withholding tax. I mean, that's what the decision says. That's why I took the court, I'm afraid, fairly slowly this morning through the underlying decisions.
Yes, well, and that is a public law decision, but where does that get you?
Well, my Lord, what that establishes is that SCAT is relying upon revenue legislation in Denmark
Yes.
to conclude, well, SCAT, when it takes the decision to make the refund, is accepting under Danish tax law that that refund is due. And the refund that is made is a refund of income tax because it is recognised there is an entitlement under a double taxation convention for that income tax to be repaid to the applicant. Now, that may or may not be right or wrong. In SCAT's case, those decisions were wrong. But that necessarily sets the starting point for what this claim is about. And it doesn't lose its tax clothing simply because the revenue then say, well, this was obtained as a result of fraud. That's my first proposition. The second proposition will be whether or not it's a refund of overpaid tax or whether it's an imposition of tax can't sensibly make a difference because there are a series of taxes where it can't conceivably make a difference because one is the obverse of the other, naturally.
Well, I haven't made a note of your second proposition, but I hope you'll expand on it
It's
and
the refund.
state it again.
It's whether it's a refund or whether it's a charge to tax, you see, doesn't make
Doesn't
a
matter.
difference.
It doesn't matter.
So the first point is, does fraud make a material difference? Our answer is no. The case law is replete with examples of sham transactions being alleged. Hitch and Stone, for example, my Lord Briggs's judgment in Old Dempster involving VAT. Both of those were statutory appeal cases involving HMRC, both inland revenue in the case of Hitch and Stone. Both of those involved allegations of sham. So fraud can't make a difference. Indeed, one could play, if one had the inclination, a rather curious parlour game and imagine tax lawyers having a dinner party together. One perhaps wouldn't want to join it. But they would be capable of thinking of any number of tax regimes where part of the regime involved a refund. And indeed, at page 1485, Philip Baker KC for AccuPay came up with various examples. More concretely, perhaps, imagine that there's a French company with a permanent establishment in the United Kingdom, and let's assume that it fraudulently fabricates purchase invoices to support both reclaims of input VAT and deductions for corporation tax purposes. Now, both of those taxes are self-assessed tax. Imagine that the truth doesn't come out for several years, and the self-assessment returns have been processed such that the French company, through its permanent establishment, gets the benefit of both a repayment of VAT and a deduction against corporation tax. Now, would HMRC be able to pursue the French company in a French court in a civil claim to recover those sums? Answer no, because HMRC would be seeking to enforce tax debts extraterritorially in France, and the French courts would disown such an attempt. Now, that would apply even though HMRC were contending that the fictitious invoices were not real invoices. You've also got my point that it can't be related to the specific identity of the taxpayer because it would be open to a taxpayer also to simulate an identity and trigger a permanent establishment or a registration in the United Kingdom as a precursor to then having the fictitious invoices scheme and withdrawing through an extractive fraud money from HMRC. Again, it wouldn't be open to HMRC, we say, to try and enforce that claim in the Paris courts.
But that's a VAT example, isn't it? It's not a corporation tax example.
The corporation tax example would be if, losses would be rolled over against...
with corporation tax, what has happened as a result of the fraud is that the company has paid less corporation tax than it should have done. So then the revenue is seeking payment of the corporation tax that should have been paid. So that's a claim for tax.
Yes, it would only be otherwise.
So that's not analogous to our case.
I accept it would only be if there was some mechanism by which a negative loss position could be extracted from HMRC, which
Well, it can't. So that's that.
A better example then is the excise case I was referring to earlier, where you have an excise drawback claim, and that precipitates a refund. I mean, anything that
is there any authority on that in this field?
There's the decision of the Court of Appeal in the Knutsford case. Sorry, Hammond's case. Page 3804 in the judgment of Lord Justice Newey.
3804.
Tab 46. Paragraph 16. His Lordship cites some evidence that was given in that case. Any scheme which refunds tax, as the drawback regime does, is likely to be a target for fraud. She went on to say that in 2009, HMRC estimated the level of drawback-related fraud to be about £25 million a year. So if people fabricate export transactions to France, claiming that goods upon which excise duty has been paid in the UK are now commercially available in France, then the consequence would be a refund of excise duty drawback would be paid out. If that turns out to be fraudulent and wrong, there's quite a lot of examples of cases where that has been the case, HMRC bring a claim for recovery of the duty drawback that shouldn't have been paid out.
Oh, I'm sure there are. I meant whether there was anything about the application of the revenue rule for such claims. No.
This is the first decision to reach this level of our court structure since Williams and Humbert, directly dealing with indirect enforcement or direct enforcement of the revenue rule, bar in Norway, of course. But that was not really dealing with the application of the revenue rule as such, simply recognising that it existed.
In the excise case, the drawback, the position would be that the taxpayer would have been charged the tax and then it's claimed back again. So there would be a relationship of taxpayer and taxing authority in place, and in seeking to recover the drawback, what one would be receiving is tax that was due. Is that not right?
The drawback would be a refund of excise duty that had been paid.
Yes.
And by accepting it, for example, HMRC, if they accepted that duty had been paid, but it was based on a fictitious invoice, for example, HMRC would be making a refund of excise duty which was not in fact due, for the sake of argument. Or imagine...
but there would be, if the drawback was paid out as a result of a mistake or fraud or whatever, then the claim would be getting back tax which was due.
It would be recovering tax that should not have been paid out. If it was a fictitious invoice with no underlying consumption, it might be arguable as to whether or not any excise duty was due, because of course...
Well, the arguability isn't the point, it's the nature of the claim. If the claim was, you've paid excise duty, you've made a claim for drawback, you've been repaid the money, pay us the money that was repaid to you. Throughout that, there is tax due by the defendant to the taxing authority.
Subject to my fictitious example, that would be, in the ordinary run of cases, that would be right, but one can imagine a scenario in which the entire operation was based on fictitious paperwork,
yes.
At which point no tax would ever have been due, but the taxpayer had wrongly recovered excise duty drawback. And that, we say, would be analogous...
You would say that's the closer analogy.
That's the closer analogy.
Yes,
yeah.
I see that, yes.
Now, one also needs to bear in mind a point that I won't go to, but it was developed in the transcript before Mr. Justice Andrew Baker, page 1450 to 1451, that the learned judge there recognised that if it's right that you need to consider whether or not the eligibility criteria were in fact met and whether or not, to put it colloquially, a tax scheme was effective, you could end up in a position whereby the revenue rule applied to part of a claim and not other parts of that claim. Because if it turns out, for example, that SCAT is wrong, that the eligibility criteria weren't met at the main trial, somebody shows that in fact they were always entitled to this refund, then you end up in the slightly perverse position that after a year-long trial, at the beginning of or middle of 2025, when one ends up in a position where the judge is recognising that revenue rule would have applied all along, which is an unusual position.
Which paragraph was that in?
Well, it's in the transcript at page 1450 to 1451, where Mr. Justice...
It's an exchange.
It's an exchange between the learned judge and Philip Baker, KC.
Thank you.
Now here we say the WHT applicants were taxpayers for the simple reason that they were recognised by SCAT to be eligible for a repayment of income tax, and that brings them within the tax net.
So regardless of whether any tax was paid on their behalf?
Regardless of that, yes, it's a mistake, but that is sufficient to bring them within the scope of the tax regime. In the same way, a fictitious taxpayer establishing a fictitious series of supplies of a VAT could also be brought within the scope of the regime. The issue here, we say, is what is the nature of the debt that is being alleged? And if that debt arises from or is related to a legislative tax regime, then that brings it within the scope of the revenue rule, either because it's the direct enforcement or because it's seeking to obtain a refund of income tax that has been wrongly paid.
So you say, yes, it's an important submission. The issue is what is the nature of the debt that's being alleged, and if it is what in relation to the tax scheme?
If it's a debt that arises as a result of the application.
Sorry, you're going to have to go a little more slowly.
I'm sorry.
For my benefit.
Of course, my lord, I'm sorry.
So what is the nature of...
The nature of the claim, if the nature of the claim is that a debt is said to arise as a result of the application of a foreign tax regime, then that brings it within the scope of the revenue rule.
Yes, I see that. So what you're saying is you're within the scope of foreign tax regime because you were recognised as being entitled to the refund.
Yes.
And you say that if a mistake was made, whether through negligence or through fraud on the part of the putative taxpayer, then you are within the tax regime, and therefore you are within the revenue rule because it's you say it's an enforcement of tax.
Well, they're trying to enforce a liability that arises only in the context of a foreign tax regime. So it's the indirect enforcement or direct enforcement for the WHT applicants of an overseas tax regime. And that's what the decision, the preliminary decision and the final decision show you, is the money that is being sought is to recover the funds that they've expressly said have to be repaid. The quantum that is claimed is the aggregation of all of the WHT applicants over a period of time. And they are saying we are relying on Danish tax law to recover these sums because you didn't meet the criteria for the refund in the first place. And so it's the extraterritorial application of the Danish tax regime in this jurisdiction. And perhaps the strongest parallel is with MTIC fraud trading, and I'm conscious that Lord Richards wanted me to be clear about how we say the parallel with MTIC fraud in VAT applies. And with your permission, I'll therefore go to the Mobilex judgment of the Court of Appeal at page 3703.
You shouldn't assume, on my part, any familiarity with this.
Which page is this?
Page 3703.
Zero.
With that in mind, could I perhaps give a high-level view of what is called MTIC fraud? It's missing trader inter-community fraud. Imagine you have a series of high-value, low-bulk items like mobile phones, which are capable of being sold from the United Kingdom to France to Germany and then back to the United Kingdom. The person who initially sells, the way that the fraud is said to operate is as follows. The person who initially imports those phones into the United Kingdom will suffer import VAT on the transaction, but will then be able to charge output VAT and will be able to set off the two against each other. And a debt therefore arises to the revenue as to the difference between the import VAT as input tax and the output tax that is due on the sale within the United Kingdom. That sale of phones then goes through a series of what are called buffers, so transactions typically taking place within a warehouse where there's simply a paper transaction and phones are sold, 100 phones are sold from A to B to C to D, each of whom then charge VAT and reclaim VAT on the previous transaction. So there's an output tax charge and there's an input tax charge that gets chased down the chain. At the end of that chain, there is somebody who is described by HMRC as being a broker, and what that broker does is it recovers the input VAT, but then because it's exporting the phones to France, it doesn't have to pay any VAT on that supply. And the reason for that is because the Principal VAT Directive says an intra-community removal of goods is effectively exempt from VAT, but you can still get the input tax back. And what then happens is the first transaction in France has to charge French VAT on the import in the same way as the UK import charged VAT at the start. And what that leads to is that broker making the export of phones to France has no output tax liability, but then has a sizable input tax claim to be able to recover all of the input tax and not have to pay anything out. And typically that broker is then asking for hundreds of thousands of pounds every quarter, or indeed every month, from HMRC in terms of a refund of the VAT that is said to be due to it. What then happens is the same chain is replicated in France. It leads to a sale from France to Germany. Chain's replicated in Germany. And in a pure carousel fraud, what happens is the original phones have simply gone round in a circle, hence it's a carousel, and the German phones are then supplied back to either the same or another trader in the UK, and the whole thing starts again. What then happens is the first trader in the United Kingdom goes missing, or defaults, or becomes insolvent, doesn't pay the tax, so HMRC is out of pocket at the beginning of the chain. Everyone else in the middle of the chain may or may not pay for tax, but you then have a repayment to the broker at the end of the UK chain. And so the UK is left with nothing coming in and a lot going out. And if that's replicated with regularity and in a series of circular transactions, it leads to very substantial sums of money going out the door. The Mobilex case was about that type of fraud.
There is, it may be in Mobilex, but I think in other cases as well, there is a sort of clear summary of the way. I'm not saying yours wasn't clear, but one can find it in writing for those of us who would like to do so.
Absolutely.
As I would say, there may be one here.
Yes, I mean, certainly Lord Justice Moses explains how the fraud works. At page 3708, paragraph 9, he refers to a complicating feature, which I think is probably not for the uninitiated, which is the system of contra trading, where you would have clean chains being used to launder dirty chains so that you reduce the amount of money that is being claimed. But it's certainly true that there are, within the authorities, a detailed description of how MTIC fraud works. We'll try and find a good example so that it's clearly set out. But just in terms of Mobilex and what the court's reaction to it was, at paragraph 31 to 35...
What is the claim in Mobilex? Yeah. Sorry.
Well, the claim in Mobilex was to deny the broker who has submitted the input tax claim It was a denial of the ability to reclaim that tax.
And usually it's too late because the revenue is paid out on the reclaim
Yes.
before the money fails to come in from the original importer.
Yes.
So it's usually more than just a denial of the reclaim, isn't it?
It can be a mixture. So you have a denial for the ones that they have caught on to in real time, and then my Lord's absolutely right, you will have assessments to tax for everything else. But it depends really to what extent the ship has sailed and they've already paid out on the refund claims earlier. So those would be recovered by way of recovery assessments under Section 73 of the VAT Act. But what we see at paragraphs 31 to 35 and 36, pages 3714, is a recognition that the ability to go against these transactions had been circumscribed by a series of CJEU authorities. So initially, in the case called Optigen, see paragraph 31, the Court of Justice had said, well, you have to look at the transactions, and if they are valid transactions by themselves, there's no going behind that. You can't simply look at somebody else's transaction in the chain. There was then a development in Cattell, which is summarised at 33 to 36, where if it was shown that a taxpayer, even if he wasn't directly participating in a fraud, knew or should have known of a fraud somewhere else in the transaction chain, that taxpayer could have its input tax recovery denied, and I would suggest by parity of reasoning an assessment could be made against it for recovery of any tax. The test for Cattell is then set out at paragraphs 41 to 42. And essentially it boils down to a knew or should have known of a fraud somewhere else in the transaction chain test. And what we see then
It's knowing participation in someone else's fraudulent evasion of tax.
Yes,
So it's knowing that somebody up the chain, usually the importer, is going to disappear and not pay.
exactly.
Not because it gets into financial gin jams, but because it never intended to pay in the first place.
Yes.
Yes.
And essentially the allegation is made, typically, but the reason why you knew or should have known is this was too good to be true, all of these deals were orchestrated, it was going around in circles, you must have known what was going on. In paragraph 43 at page 3717, there's an important finding from Lord Justice Moses, that the presence of fraud and knowledge or means of knowledge of it is such as to mean that the objective criteria for the VAT refund being payable ceases to exist. And one of the arguments that was raised in Mobilex was you need a domestic form of implementation of that, to which the Court of Appeal said no, it's inherent in what was then the 6th directive, that if you don't meet the objective criteria for an entitlement to a refund of VAT, you don't get the VAT. And so the point is, we say, the way this works is that the effect of fraud is to remove the objective criteria for the entitlement to tax being paid. And in these cases, therefore, it's incumbent upon the revenue, who bear the burden of proof, to show that the objective criteria for the repayment of VAT, or for the payment of VAT, was never met. And we say the position is no different here, because what one has to do in order to put yourself in Scat's shoes is establish that the objective criteria for the payment of the refund was never met. And the fact that they're alleging fraud on that doesn't take the position out of the usual position. And we say, if one applies the logic of Lord Collins in his comment on the Sunico case, it's not open, it wouldn't be open to the Irish revenue to pursue an English company for loss caused by participation in an MTIC fraud. The Irish tax revenue would be asserting that the objective criteria for the payment of any VAT or for any refund of VAT had not been met for transactions within Ireland. They would be saying fraud has undone the objective basis for us to have recognised those tax payments and those tax refunds, and we therefore want our money back. And we say that's exactly the same exercise that is engaged in here. Now, there have been at least 2 examples of HMRC pursuing non-UK taxpayers to recover these types of losses occasioned by fraud. So this is a case where the UK can't go after a UK taxpayer either because there is no money or they don't have funds. So they go against a non-UK taxpayer to recover damages for compensation to make up for the tax gap caused by their wrongful recognition of an entitlement to a refund. The first of those is the Total Network case. I'm afraid I'm going to have to take this relatively quickly because I do have still, unfortunately, a few things to get through. The Total case involved a claim by HMRC against a Spanish trader. It's in Authorities, tab 55, page 4232. I think this may be where one finds a more coherent explanation of...
Yes, Lord Justice Ward quotes it
fraud.
in paragraph 2 of his judgment, 4237.
Thank you very much, yes.
Yeah.
In essence, the UK brought a claim against a Spanish company saying what you've done is you've fed phones into this carousel system, and by feeding the phones in and then buying them back again, you've enabled other people to go missing with the tax at the top of the chain and then to claim back VAT as the broker at the UK export end of the chain. One of the questions that arose was, is it open to HMRC to bring a civil claim to recover those costs, or should it actually be legislating to have a statutory mechanism to achieve it? Answer on that issue, 3.2, was HMRC could bring a claim. But in the course of making a decision as to whether or not the VAT Act provided an exclusive statutory mechanism for recovery of VAT by HMRC, three of their lordships identified the nature of the claim that was essentially being made by the damages claim. I accept that Lord Scott and Lord Walker took a slightly different view, but on this particular issue, classification of the claim, we have Lord Hope, Lord Mance and Lord Newburger, who all chimed with each other as to the appropriate way of going about classifying the claim. Could we please turn within the speech of Lord Hope to page 4279. And he recognised in paragraph 1 that one of the issues was whether it was open to the commissioners to maintain a cause of action and damages at common law as a means of recovering VAT from a person who has not been made accountable or otherwise liable for that tax by Parliament. So there was no direct connection with that taxpayer, but at the same time what was sought to be obtained was filling the hole, the tax hole, in the VAT regime. And his lordship then, at paragraph 18, page 4284, recognised that there was no statutory provision by which these sums of VAT that were said to be triggered by the defendant's action could be recovered. No provision either was made in the 6th directive. He says there is no statutory remedy against Total. The other people involved in the chain, on the other hand, are within the reach of the statute. The broker's failure to pay, the defaulter's failure to pay was a breach of section 25, and the broker, i.e. the exporter, can be assessed under section 73(2) for an amount of VAT due from it to the commissioners, which is equivalent to the amount of VAT that is recovered as input tax on the ground that the commissioners would have been entitled to withhold payment of the VAT if the purpose of the transaction had been disclosed to them. So that's recognition of the point my Lord Briggs made. The ship here has sailed. If they'd realised at the time they could have stopped the refund, they failed to do so. Seemingly there must be recovery issues against the broker, so they're going against the Spanish company for having caused the tax loss, even though that Spanish company isn't part of the UK tax regime. Now, to similar effect, at paragraph 25, 25, page 4286, again, still within the speech of Lord Hope, one sees that the nature of the Commissioner's claim is explained, and At the heart of this argument, he says, there lie more fundamental questions about the nature of the Commissioner's claim and their interest, if any, to seek to recover tax wrongly paid or credited as damages against a person upon whom no liability to pay that amount can be imposed under the statute. And that was then reiterated at paragraph 29, page 4287. Letter G, His Lordship says, there is, it may be said, a gap in the statute, but this does not mean that the Commissioners have suffered a loss for which they can sue in damages. All that can be said is that payment was made to Aldec, which ought not to have been made. It is an amount that can be recovered as a debt due to the Crown from Aldec.
Which paragraph are you in now?
Paragraph 29, my Lord.
29.
Letter G, G to H.
Right.
It is an amount that can be recovered as a debt due to the Crown because of a provision of the VAT Act. It does not change its character as a debt due to the Crown because when it is sought to be recovered from someone else, it is described as damages. So when you're trying to make good a wrongly paid VAT refund, and you seek to do so through a claim for damages, that properly understood is treated as being equivalent to a claim for recovery of the tax itself.
Aldec was the broker, presumably?
Yes. I think Aldec was the broker and the other company I mentioned, Redlaw, was the defaulting trader. Now, true it is that was directed at the issue of whether or not the VAT Act dealt with the statutory code, but it does show how their lordships were thinking about how to characterise the claim. And then if we turn to Lord Mance, please, page 4230.
Sorry.
4230. Paragraph 127. That can't be right. That's not right. I'm sorry, I've got the wrong references. It is paragraph 127. I'm pretty sure of that. I've got the wrong page number.
It's 4319, is paragraph 127.
Thank you very much. And we're in the speech of Lord Mance, top of the page on 4320. I've transposed the digits.
Yeah.
Top of the page, the Commissioners are claiming damages against a conspirator, Total, whose wrongdoing either prevented the recovery of tax which was due under parliamentary authority or led to the Commissioners mistakenly paying to the broker a VAT credit which was not due and which is in law recoverable under parliamentary authority. And we say that approach chimes with what the SCAT is seeking to do in this case. Again, paragraph 128, by letter F, His Lordship says, and if, as their primary case involves, the Commissioner's loss is their inability as a result of the...
Sorry, you're on
page 4320 still, within paragraph 128.
128, thank you.
By letter F, if the Commissioner's primary case is that their loss arises from their inability as a result of the conspiracy to recover VAT due from the missing traders, the recovery of such loss seems to me to fall within the scope of their competence. End of that paragraph, by letter H. Again, the claim is not for the VAT due or repayment of the VAT credit, it is for damages in respect of the loss suffered by the Commissioners due to a successful conspiracy to manipulate the VAT system. So the fact that it's not a direct claim for the VAT due internally within the UK system doesn't mean it isn't seeking to recover missing VAT, missing tax. It is. The recovery is there, it's just not going through a statutory mechanism. And we say that the parallel applies here. Finally, Lord Neuberger, page 4324, we see paragraph 140, core allegation is that Total was party to a so-called carousel fraud, which resulted in the Commissioners not recovering VAT which they should have recovered, or paying an alleged VAT credit which they should not have paid. The preliminary issue to be determined is whether the Commissioners have a cause of action against Total as pleaded. So one of the issues was nature and extent of unlawful means conspiracy and whether or not you needed to have a direct cause of action. Answer no. Paragraph 196, page 4337.
196.
196, page 4337. His Lordship explained, if each transaction can be treated as bogus, then the Commissioner's claim fastens not on the output tax which should have been paid by Redlaw to the Commissioners, i.e. the defaulting trader, but on the payment of the commissioners to Aldec, the broker, in respect to the purported input tax claim, which should not have been paid. Going back to Mobilex, the criteria for the refund of VAT was vitiated by the fraud, and therefore the criteria for the repayment of that refund never existed, or should not have been treated as existing, and the commissioner's claim was then to get the money back to reflect the refund that never should have been made in the first place. And we see at 197 to 198, a submission was made that somehow, because this was seeking to recover money extracted by fraud, that meant that the VAT regime fell away. And his lordship said, attractive though that submission and indeed its consequences may be, it does not appear to me to tie in with the wide way in which the provisions of the 94 Act extend the scope of evading VAT or obtaining a VAT credit. Last sentence, it appears to me, therefore, that the legislature has decided to extend the statutory regime in explicit terms to cases where money is wrongly claimed and paid out as a VAT credit, which would apply here in relation to the claim made by Aldec. So whether or not it's treated as a failure to pay, defaulting trader, or as a wrong payment of a refund for the broker, his lordship is saying this is a claim to recover wrongly paid VAT. It's a VAT claim. And for that reason, his lordship, in the minority, concluded that the VAT regime should provide the exclusive means of enforcement. Now, on that issue, he was in the minority because the rest of their lordship, three of their lordships, found that just because the VAT Act gives you a statutory mechanism for recovery doesn't preclude, in this case, a civil law claim for compensation. But what I'm focusing on is the characterisation of the claim in the House of Lords decision. And the characterisation of the claim is one for recovery of undue VAT.
In a way, paragraph 198 rather suggests that that characterisation was itself the result of a very careful and painstaking analysis of the VAT scheme, rather than one that just flowed from an appreciation or understanding of the basic facts. So that it might not be a very powerful analogy for transferring across into a Danish legislated scheme about withholding tax.
But the mechanism of the fraud...
It's Lord Richard's point this morning.
I accept that there will be quirks of VAT which make things different. But the point about inputs and outputs and refunds is, as we've seen from the Hammonds case, common to many taxes. Many taxes end up with refunds potentially being payable. And we have the judgment of Lord Justice Newey and Hammonds saying whenever refunds are going out to a taxpayer, you have the risk of fraud, which we respectfully recognise. So, yes, there will be nuances in the regimes, but all of these regimes are geared towards the proper payment of the tax. And if the tax hasn't been properly paid in the first place, you will need to make a claim for it. If the tax has been wrongly refunded, you need to make a claim to get it back. And that's what the VAT regime also permits. If one looks in the authorities bundle at page 3735, at the Bilter case...
Can I just ask you, if it were a claim for the recovery of input tax, would HMRC have to make that claim through the tribunal system and through the statutory machinery?
No, says the House of Lords in Total. They can
well, is that what they're doing? I thought in Total it's a claim for damages for conspiracy.
Yeah, so if
the claim was we want to reclaim the input tax that we've paid you, is that a claim which under the tax legislation, relevant tax legislation, would have to be pursued through the statutory machinery of an assessment or whatever it is and appeals to the tribunal?
I'm not sure. I'm afraid I know the answer.
Could HMRC just issue a claim form claiming repayment of input tax?
Well, I think on the authority of Total they probably could.
But that's not what it was. It was a claim for damages. They clearly couldn't bring a claim for damages in the tax tribunal.
No, they couldn't. So
nor could they assess someone in a claim for damages.
I perhaps misunderstood my Lord's question. I thought you were asking me.
I was asking procedurally, what is the machinery available to HMRC to recover input tax, not how to recover damages for conspiracy.
Yes. So if they invoke the statutory mechanism...
Or do they have to invoke the statutory mechanism?
That's the question I thought I was addressing. Which,
No. Well, sorry. Total is a claim for damages.
Yes.
You can't assess a taxpayer for damages for conspiracy.
No.
But you could assess a registered trader for overpaid input tax.
Yes.
Now, in that case, that's done through the statutory machinery.
Yes. Do they have to?
Yes.
Or could they bring a separate claim for damages for loss?
No, could they recover the input tax?
If they raise a statutory assessment,
Well, they have to, don't they? That's the only way of recovering input tax.
Well, I think that's the question that's left open by the implications of Total applied to the purely domestic regime. Now, I can answer the converse question, which is, can the taxpayer...
Let's just put it this way. It's hard to imagine why HMRC wouldn't use the statutory machinery, isn't it? And that would seem to be the way it has to be done anyway.
Well, that I'm afraid I can't commit to. What I can say is that the converse is true, which is that this court has held that the only mechanism for obtaining a repayment of VAT is through the statutory mechanism, Section 80. A repayment of overpaid VAT by the taxpayer has to be brought through Section 80 claims. That the court has decided. The reason I'm being difficult,
I see.
If it's perceived as
yes, so the
is I can't commit to the converse being true.
Right.
I should say I'm going to have to, I'm afraid, pass over Sinico because of time, but my Lords will find at page 3190 that a similar claim for recovery of tax, UK VAT, was pursued by HMRC against a Danish company, and again the claim was brought in this country. Sunico had a rather convoluted procedural history that I think, for present purposes, I'll have to deal with tomorrow if it comes up by way of reply. Could I turn, though, to Bilter? Because I'm conscious that my Lord Richards is keen to understand whether or not the intricacies of the VAT system make any difference.
I'm not sure whether any of my lords are equally interested, so don't necessarily waste your time.
You would be welcome at the imaginary dinner party, my Lord.
Oh, dear, no, please.
Would you be kind enough, please, to turn to page 3735? It's a decision of the Court of Appeal in NatWest Markets and Bilter. And this, again, is a useful description of an MTIC fraud. Yeah. The reason I'm taking my Lords to this is because, unlike tangible goods, this involves an emissions trading scheme. Please could I invite the Court to read paragraphs 6 to paragraphs 11 for the relevant facts and a summary, actually, of how MTIC fraud works.
Where are we to read?
Up to paragraph 11, please.
Thank you.
Paragraph 14 over the page then describes how, at a certain point, the over-the-counter transactions became more institutionalised, and the Royal Bank of Scotland entered into a joint venture with Sempra, which operated through a limited partnership, as a result of which trading in carbon credits, including the allowances through the emission trading zone, was achieved through a financial desk, essentially being treated as a form of commodities trading in a financial institutional basis. So, akin, we say, to the allegations here that there are convoluted financial instruments and financial dealings being used to perpetrate a fraud. Now, the allegation of fraud here was a carousel fraud, see paragraph 17, and what this case led to was a claim by the liquidators of the companies to recover back sums which were due by way of VAT as a result of that complicated financial orchestrated fraud, with VAT being unpaid when it should have been paid, or refunded when it should have been refunded. And we say that that's an example of liquidators seeking to bring a claim for recovery of the missing VAT. And of course, that would walk straight into the rationale behind Buchanan and McVeigh. And we say, following on from these cases, there should be no distinction in principle between claims in which a revenue authority is saying we have wrongly made a refund of tax, and cases where it's saying you've walked off without paying the tax that was due. And the permutations extend to suing persons who are not party to the transactions for their participation in it, providing the merchandise which stoked the fraud, and also extend to claims by liquidators for enforcement against directors who have wrongly allowed their companies to take part in these frauds, and that is the Buchanan and McVeigh example. So we said there's no real sense in this case in which SCAT is enforcing rights akin to those of a private person. What it's seeking to do, as Mr. Justice Andrew Baker found, is fill the tax gap left by their decision to refund erroneously £1.4 billion worth of income tax refund claims. And we say that brings within it necessarily the legislative tax regime in Denmark, because that is the foundation for all of the claims that are subsequently made, as the learned judge at first instance rightly found. Now, there has been lively, to a point, academic commentary on the Chancellor's decision. There are competing academic articles, one of which has been written by Philip Baker KC, that we have a reference to in our written case. Another has been written by Professor Briggs, who is never dull, and his article reflects that. And SCAT relies upon Professor Briggs's article. All I can say in response is never dull, but not always right, with respect, and indeed found not to be right, for example, in the Brownlee case. But it is what it is. I'm afraid I don't have time really to turn to. With the greatest respect to Professor Briggs, that's what you want an academic to be. Interesting, but not necessarily always right. The people who are always right is this court, of course. And the answer lies with this court as to what the answer is to this difficult issue of classification of the claim for the purposes of the revenue rule. Unless your lordships have any questions for me, I'm going to move on, if I may, to ground two. This is covered in our written case, paragraphs 82 to 94, and in my learned friend's written case, paragraphs 125 to 145. And the way that this ground arises is if, for any technical or non-technical reason, the revenue rule is for any reason not applicable. So either because it's perceived that what is going on here is not a tax claim, or because the refund that has been cancelled or annulled, rescinded, takes it out of the scope of a legislative tax regime for whatever reason. We still have a fallback argument that this still represents the extraterritorial enforcement of public law. Public law, admittedly, is the very same legislation we rely on for ground one, but if the concern is that it doesn't fit the tax criterion, then the alternative answer is, well, it's still an exercise of sovereign authority by SCAT seeking to enforce its public laws before the courts of this jurisdiction. Please could I invite the court to go to page 2048 and the Court of Appeal's decision in Embasogo. So that's 2048. The facts, which are colourful, are set out in the head note. As the court, I'm sure, will recall, this was an attempted coup by various conspirators against Equatorial Guinea, and Equatorial Guinea, in company with its president, sued the defendants for associated costs and damages. So this is 2048. Sorry. And And the headnote sets out the holding. There was a fundamental distinction between an action which amounted to the exercise of sovereign authority in the territory of a foreign state, which was not justiciable in the English courts, and an action brought by a sovereign state to protect property rights, such as might have been brought by an individual, which was justiciable. And the second claims were not founded on the claimant's property interests, but were in respect of losses which arose as a result of decisions taken by the claimants to protect the state, which could only have been suffered by the governing body of the state, and therefore the second claimant's claims amounted to the exercise of its sovereign power within the jurisdiction. Now, the way that the judgment of Sir Anthony Clark, Master of the Rolls, at page 2060, then approaches the matter is to set out at page 2064 the rival contentions on justiciability. So at paragraph 17, we see His Lordship setting out what the defendant's submission was, namely that the claim for damages was not justiciable. Underlying point was that this was involved an exercise of sovereign authority by Equatorial Guinea in our courts, and the claimants, however, responded that that misdescribed the true nature of the claim. Properly understood, these were conventional claims for compensation. Now, if we transpose that into our case is that this is an exercise of sovereign authority invoking the tax laws of Denmark to achieve a result, and SCAT says, no, these are conventional property claims similar to a patrimonial claim. A private individual could have brought a similar claim. Paragraph 27, His Lordship identified a key distinction between acts which amount to the exercise of sovereign authority in the territory of another and an action brought to protect property rights. So that is one of the key distinctions. That 27, page 2068. We then see paragraph 31 and 32, quite a detailed exposition of why that distinction applies. Please can I invite the court to read paragraphs 31 and 32. Then at page 2071, there is a reference to the speech of Lord Mackay in the Williams and Humbert case. And at the top of page 2072, the Master of the Rolls explains why that doesn't cast doubt on the principle established under the Revenue Rule. Please could I then invite the court to read paragraphs 40 to 43. paragraphs 50 to 51, page 2075, then have the learned judge's conclusions and application here. Sorry, the application is then dealt with subsequently, but the overall conclusion on the law.
Is it paragraph?
50 and 51.
Thank you.
Conclusion on the facts is then at 2078, paragraph 63. There's a finding that the pleaded claim is not enforceable. It applied effectively the sovereign power principles set by the Government of India case. And at 66, the court also took into account, in a sense, how can I put this, the diplomatic potential for embarrassment, or the potential for diplomatic embarrassment as a relevant factor. Now, I think have time to turn up or tease the judgment of Lord Denning, but it's cited in any event in the passages that I've referred to the court. We've seen that it's been endorsed in other case law as well. Now here, the exercise of sovereign power takes several forms. Firstly, we know that Denmark has chosen to impose the tax regime that they have put in place. It's chosen to charge 27% income tax. It's chosen to require the companies that pay dividends to make that tax available to the state, and it's then chosen to give effect to its double taxation convention obligations by establishing a refund scheme. All of those facts, stroke legal regimes, are highly pertinent to the way that the claim is brought here by SCAT, and necessarily claims to recover monies that have been wrongly paid out under that legislative scheme, including through the wrongful application on SCAT's case of the double taxation convention obligations, is necessarily bringing with it the exercise of sovereign powers and an exercise of a sovereign act. There's also the additional point here that SCAT has itself deployed extensive public law powers when collecting information and gathering evidence. And I would invite, please, the court to look at page 935 of the appendix, which forms part of a pleading, but it summarises in short form a series of references, some of which is taken issue with by SCAT, but it does at least set the factual background. So at page 935, and tab 22, I'm afraid I'm simply going to have to take this by reference to the headings.
What are we looking at here?
We're looking at examples of exercises of sovereign power.
This is in defences.
It's in a defence that has been submitted by Mr. Charles Norton and Mr. James Hugerworth in this case, and I will take you in a moment to SCAT's pleading in response, which recognises that some of these requests for information have indeed been made, and then seeks to recharacterise them or take issue as to how far one can go. I simply, I'm afraid, I'm going to point to a series of requests that have been made for various assistance. By reference, I'm afraid, to no more than the headings, because I don't have time to develop in detail. But one sees at page 936 that the Specialist Prosecutor's Office has been approached. Other parts of SCAT are dealt with at page 937. Interaction with the German authorities is dealt with at page 938. Page 939 deals with the interaction with the UK authorities. Page 940 moves on to the United States authorities and the IRS. And 941 then identifies Malaysia, the German Ministry of Finance and the Canada Revenue Agency, as well as the Swiss authorities and so on. And in order to make good the point that some of these at least have been accepted by SCAT, please could we turn to page 957. Within, one sees in passing, page 951 is the first page of that re-amended reply to that defence. But if we then please turn to page 957, there is an admission at paragraph 12.1 that SCAT has used some of the documents obtained in Danish, British, Luxembourg and German criminal investigations. With the consent of the Malaysian Attorney General, SCAT has also obtained documents provided to Zurich by the Malaysian police. It is denied SCAT obtained such documents as the exercise of public powers. Page 974. SCAT deals with the request for assistance made by HMRC pursuant to Directive 2011-16, which is the Mutual Assistance Directive that I referred to earlier. It's not marred. I'm afraid.
Which paragraph are you reading from?
32.1. Over at the top of the page 974 refers to HMRC responding to a mutual assistance request and providing what is described as HMRC directive material. And it's recognised that a request under the directive could not have been made by a private person. We then see at the bottom of that page the only other requests made by SCAT under the directive relating to the subject matter of these proceedings were to the German Federal Ministry of Finance. It then refers to a paragraph pleaded below. 975 deals with dealings with the US authorities and the IRS. 977 recognises that material has been received from Malaysia. 979 recognises material has been received from Canada, and 980 acknowledges receipt of material from the German Ministry of Finance. For your note, page 1755 in the appendix has the IRS confirming that because the request for information arose out of an alleged dividend fraud, tax fraud scheme, it was considered that the request for information was covered by mutual assistance provisions in the US-Denmark Convention relating to the administration of taxes. That's
This is page
1755. It's cited in our case as well.
Yes, thank you.
Now, SCAT says in response to this particular ground, well, we can also rely on a public policy exception to it. I propose to deal with the Barakat case in reply, but can I get some retaliation in first, briefly, just to simply say that when, in due course, my learned friend takes this court to Barakat, the basis upon which a public policy exception is identified is quite difficult to discern. Because, of course, if it's right that there is a public policy against recognising the admissibility of a claim because it amounts to the extraterritorial exercise of sovereignty of another state, then it's difficult to see what space is left for a court to say, well, we quite like that extraterritorial exercise of sovereignty, therefore that's okay, because that places the court in the invidious position of deciding which exercises of extraterritorial sovereignty are good and which are bad. And we say that the revenue rule is designed to avoid that analysis. But on any view, we say that the proper analysis, in fact, was offered by Mr. Justice Andrew Baker, paragraph 92 of his judgment, where he said that that analysis of what is the underlying public policy principle that has to be either respected or enforced necessarily comes into a consideration of whether or not this is a public law, full stop, for the purposes of the revenue rule. We say that's a better way of accommodating any particular balancing of public policy interests. On this point, the public policy that SCAT invokes is that fraud unravels everything. That, of course, is a public policy that has been deprecated as being a reason to refrain from applying Dicey Rule 20, specifically in the context of the revenue rule itself. So we know from Buchanan and McVeigh it was a fraud case. We know from QRS and Franston that it was essentially an asset stripping case. Could easily have been pleaded as fraud. The reality is that the revenue rule has never set its stall on the basis that fraud itself is different, and therefore the claimed public policy exemption shouldn't be applied here. It is in truth covered, we say, by the extensive bilateral and multilateral agreements that exist in this area. The dicey Rule 20 can be upheld precisely because the states have agreed a sensible workaround between themselves. That brings me on to ground 3. I accept that ground 3 is something of a catch-all, because having looked at the analysis of the revenue rule proper, and then having looked at the extension of the revenue rule in the forms of public law exceptions, one is left with what did the Court of Appeal do in this case? And what I'm proposing to finish with is a series of 8 points where we respectfully suggest that the Chancellor has erred in his analysis of both of those issues. Firstly, we say, and most obviously, nothing in the judgment of Mr. Justice Andrew Baker, properly analysed on ground 1, is vitiated by an error of law, and we therefore commend it with respect to this court as being an accurate and thorough and conventional analysis of the revenue rule. In no way, we say, does it seek to expand the revenue rule. To the extent that it was dealing with a point for which there was no prior express authority, it was whether or not there was a distinction of principle between the imposition of a tax that is non-paid and recovery of a tax that's been wrongly paid out, or a tax refund that's been wrongly paid out. And we respectfully suggest, for the reasons given by the learned judge, there was no error of principle in that approach. Secondly, with respect, we say the Court of Appeal was wrong to find that the claim was to be categorised as one for the refund of general...
Sorry, it was wrong to...
Wrong to say that the claim was to be characterised as one for the refund of general funds held by the state that were abstracted by fraud. This isn't a case of the secure-call van with Bank of England money being detained on outside the bank. This is a case in which the specific mechanism for the fraud that the SCAT relies upon involves the intimate operation and deployment of tax legislation in Denmark. Thirdly, again with respect, we say the Court of Appeal was also wrong to find that there was no assertion of sovereign power or authority here. And the conclusion, for example, at paragraph 130 of the Court of Appeal's judgment, that a public law decision would be vitiated by fraud, does cause, we say, potential serious ramifications for HMRC's enforcement of decisions through the statutory mechanism that is available to it. Because, of course, if a decision is treated as not existing, that may raise very real issues for whether or not a statutory mechanism relying on that decision and seeking to have it cancelled can be properly enforced. If this forces HMRC to have to bring claims for compensation rather than statutory claims for refunds, then that is likely to invoke the problems that we briefly explored earlier. Fourthly, the Court of Appeal was wrong to conclude that the claim could equally have been brought by a private person. It was in fact brought by a tax authority, and the reason why the tax authority is recovering monies is because it's wrongly paid out tax. This isn't a sort of non-tax related fraud arising from an official within SCAT wrongly answering a phishing email and being caught up in some scam. Fifthly, the Court of Appeal was wrong to conclude that a definitive assessment to tax was needed. See paragraph 134. We say a claim to recover overpaid tax.
Sorry, the wrong to conclude that
a definitive assessment to tax had to be
definitive assessment. Yeah.
We say a claim to recover overpaid tax would equally establish a debt or liability to the revenue. And indeed, we've seen in the VAT cases that a claim to recover the undue refund of VAT is equally possible in fraud as a claim to an assessment of tax that was due but has not been paid. Sixthly, the Court of Appeal was wrong to conclude that there was no taxpayer relationship. Short point here is it's the very act of payment of the refund by SCAT to an applicant that is adjudicated to be an eligible claimant that establishes that very relationship. Seventhly, the basis for contrasting this case from other fraud cases is, with respect, not clear. As I've sought to indicate, MTIC fraud, through the objective criteria test set in Mobilex, necessarily involves a foundational allegation that the objective criteria for payment of VAT is not met. You don't get to a stage where you are refusing a refund claim or seeking to recover for a wrongly paid refund claim unless you have established that the VAT was never properly recovered. That is the foundational aspect of the MTIC fraud. We say it applies ceteris paribus to the claim for withholding tax, which also can involve either a claim for payment of tax that should have been paid but hasn't, or a claim to recover back tax that was refunded that shouldn't have been. And finally, we respectfully suggest that what is motivating the Court of Appeal's assessment is the fact that this is a fraud case, and pleaded as a fraud case.
Sorry.
Pleaded as a fraud case, but as a matter of principle, the fact that allegations of fraud are made can't change the scope of application of a centuries-old rule. And I didn't take you to it, but the US courts have recognised, regardless of the merits of the claim of allowing a foreign revenue power to be able to recover damages for a smuggling operation committed by an individual company in its territory, hard cases make bad law, and one has to apply the revenue rule because it is the law. And that applied equally to the Attorney General in Canada as it did to the European community seeking to recover damages for the smuggling activities, alleged smuggling activities of a large multinational corporation in the United States. This isn't a case, contrary to Scatt's argument in paragraph 18 of its case, that somehow it will be denied justice here. It has a widespread, broad spectrum attack on those who are alleged to have perpetrated this fraud, involving many jurisdictions. And as I've indicated at the start, it's bringing claims against my clients in Dubai, in two different jurisdictions in Dubai, one offshore, one onshore, and it's seeking the extradition of my principal client to Denmark to stand criminal charges. Would your lordships be very kind and give me a moment? Nobody's tugging my metaphorical gown, so that brings an end to my submissions, unless your lordships have any questions for me.
Mr. Beale, thank you very much.
Thank you.
Lord Panic, do you wish to begin in the 5 minutes that's available, or do you prefer to wait for another day?
I'm in your lordship's hands. I'm very happy to start if your lordship's want to use the time.
Well, let's start.
Very well. Lords, I can summarise our submissions in this way. First of all, the revenue rule prohibits a claim from being brought in this jurisdiction only if it is a claim, directly or indirectly, for taxes due under a foreign tax law. That's what Lord Mackay said in Williams and Humbert. And we say all the authorities and the revenue rule are consistent with that explanation. The second proposition that I will seek to develop tomorrow is that our claim, Scatt's claim, is not a claim directly or indirectly for taxes due. And that's simply because, we say, no taxes are due from the appellants or from the applicants for refunds. No taxes were ever due from them. And that's because they didn't hold any shares, they never received any dividends, and no tax was withheld. It is true that Scatt was the victim of a fraud in the context of the Danish tax system. The appellants on our case used the tax system as the mechanism by which their scheme was perpetrated. But that doesn't help them, because our claim in these courts is not a claim for taxes due, and therefore the revenue rule does not apply. SCAT has been paid all the tax due to it. Our claims are and are only for civil redress of the wrongful extraction of our property by misrepresentations. The third proposition is there's no basis for the appellants to contend in the alternative that our claims are an assertion of Danish sovereignty. If the claims do not infringe the revenue rule, there's no realistic scope, in my submission, in this context, for the application of any wider exclusionary principle. That would undermine, we say, the carefully calibrated rules as to the scope of the revenue rule. In any event, the question is whether by these claims SCAT is engaged in an extraterritorial assertion of Danish sovereignty. Our claims do not seek to vindicate or give extraterritorial effect to any sovereign right or act. We are as entitled as any private party to seek a remedy where monies have been obtained from us by misrepresentation or by fraud. Far from seeking to vindicate any sovereign decision, we are resiling from the only sovereign decision which the appellants could possibly point to, which is the decision to make payments to them. Nor do we accept that somehow the appellants have become taxpayers by reason of the payments to them, when the payments to them were as the result of their own misrepresentation and or fraud. The final heading will be the international materials. I say none of that helps the appellants, because none of it prevents recovery under civil law, none of it affects the scope of the revenue rule or indeed the scope of sovereign claims. And in any event, none of the international materials, whether it's the US-Denmark Treaty, which has no application in domestic law, or MARD, none of it applies to a claim to recover sums wrongfully extracted from the state where no taxes are due. Those matters are the ones that I propose to seek to develop tomorrow with your Lordship's permission. But that's a summary of where I seek to take the court.
Well, that's very helpful, Lord Pack. It's a summary that one can perhaps detect it in your case.
Indeed, there's nothing novel in what I'm going to say.
Thank you very much. Well, the court will now adjourn and we'll resume this interesting discussion tomorrow.
Thank you, my lord.